Assalamualaikum warahmatullahi wabarakatuh. My name is Dzulfadli Rahman and my student number is D1A023101144. And now, with this opportunity, I want to explain about two materials. The first one is Customary Inheritance Law and the second one is Customary Marriage Law. So, the next material is the definition of Customary Inheritance Law based on the expert. Here's the explanation. According to Hazairin, customary inheritance law has its own style from the traditional mind of society, with forms of kinship whose descent system are patrilineal, matrilineal, parental, or bilateral. Although the same from kinship does not necessarily apply to the same inheritance system, so the nature of customary inheritance law is also influenced by the kinship system that exists in society. While according to the Supomo himself, customary inheritance law contains regulation that regulate the process of passing property goods and intangible goods from the human generation to its descendants. Previously, I explained the customary inheritance law according to the expert, and now I will explain the basis of customary inheritance law. Here's the explanation. So, the legal basis of customary inheritance law is the first one, Supreme Court decision date 18 March 1959, register number 391/K/SIP/1959, which contain the right to fill or replace the position of an heir who has died earlier than the person who left the inheritance rest with the descendant in the descendant line. The second one is Supreme Court decision date 10 November 1959, register number 141/K/SIP/1959, state that replacement of heirs in the upward lineage may also be viewed from the sense of justice. Basically, succession must be reviewed based on society's sense of justice and related to obligation to care for parents and vice versa. And now, I will explain about the principle of customary inheritance law. Here, the explanation. Customary inheritance law has a four principles. The first one is principle of divinity and self-control. This principle reflects the first principle of Pancasila, namely God Almighty. In customary inheritance law, the division of inheritance is carried out by considering religious and moral value, maintaining a balance between worldly and spiritual interests. Inheritance is not only seen as a material wealth, but also as a mandate that must be accounted for a God in the future. The second one is principle of equality and shares right. This principle is referring to the second principle of Pancasila, fair and civilized humanity. In customary inheritance law, each family member is considered to have equal rights to receive a share of inheritance, so the division is done in a fair manner without discrimination based on the gender, age, or social status. The third one is principle of harmony and kinship. This principle refers to the third principle of Pancasila, unity of Indonesia. In customary inheritance law, it is important to maintain harmony and kinship within the family. The division of inheritance is carried out in a way that strengthens family relation and prevent division. All decisions made must be taken into account the welfare of the joint so that good relations between families are still maintained. The fourth one is the principle of deliberation and consensus. This principle itself emphasizes collective agreements and not individual decisions that can cause division. This principle is referring to the fourth principle of Pancasila, democracy led by wisdom and consultation or representation. The division of inheritance in customary law is often done through a process of family deliberation. Each family member is invited to discuss and reach a mutual agreement in the division of inheritance. Number 5 is principle of justice and care. This principle refers to the fifth principle of Pancasila, social justice for all Indonesian people. In customary inheritance law, the division of inheritance must be done fairly, taking into account the needs and condition of each heir. Care itself means that distribution of inheritance will be prioritized, being given to families who are more in needed or family who are less fortunate, such as like orphan, widow, or families who have suffered a disaster. And now I want to talk about the second material is customary marriage law. First of all, I will explain what the definition of customary marriage law. So, customary marriage law is a marriage that has a legal consequence for the customary law that applies in the community concerned. Customary marriage law in Indonesia means not only as a civil engagement but also as a customary engagement, and at the same time as a kinship and neighbor lines engagement. In short, customary marriage law is the custom or behavior of other people in carrying out marriage ceremonies, which then become unwritten positive law that only applies in certain communities and has a sanction in it. And now I will explain about the legal basis of customary marriage law. Here's the explanation. The legal basis of customary marriage law is adopted from the Law Number 1/1947. Although Law Number 1 of 1947 on marriage is already enforced, but customary law still applies. The marriage law does not regulate the form of marriage, how to propose marriage ceremonies, and other within the scope of customary law. The position of customary law in Law Number 1 of 1947 is not clearly visible, but is contained on several articles, like Article Number 2, namely marriage is valid based on the religious law, Article Number 35 up to Article 39, namely regarding marital property contains provision of customary law known as a gonogini property, and Article Number 37 regarding property is regulated by their respective law. And now I will explain about the principle of customary marriage law. Here's the explanation. The principle of customary marriage law are divided into 5 parts. The first one is principle of solidarity in kinship. Marriage in customary law is not only individually binding, but also binding on the customary community in the sense that the communal community has a responsibility in the marriage affair of its citizens. Therefore, marriage in this case is determined by the will of relative and the customary community. The will in question starts from the selection of a spouse, the issue of the harness, and the other issue. This principle is actually what underlies the principle of marriage in the customary law. The second one is principle of voluntariness or agreement. In customary law, the bride and groom do not have a full authority to express their willingness or purpose of marriage. Marriage must be based on the consent of parents and relatives. The indigenous community can reject the position of a husband or wife who is not recognized by the local indigenous community. Violation of this principle can be sanctioned by being expelled from the kinship environment of indigenous community, especially in indigenous community where the tribal system is still strong, such as like indigenous people of East Nusa Tenggara. And the last one, I will explain about the marriage system in customary law. Here, the explanation. And the last material is the customary law marriage system. So in this system is divided into 3 parts. The first one is endogamous system, that is, a marriage are carried out within the clan between a male member and a female member, but marriage are not carried out outside the clan. Endogamous marriage is a recommendation that based on the importance of unity in relationship between a family in order to maintain land that remain in the property of one own neighborhood or family. The second one is exogamy system. In this system, people are required to marry people outside their own tribe. This system is often found in the Tapanuli area and the Minangkabau. And the last one is eleuterogamy system. This system does not recognize any prohibition or territorial boundary as the case with the endogamy and exogamy. This system is only use prohibition based on the blood ties or close kinship, such as like a mother, grandmother, biological children, grandchildren, sibling, father or mother sibling, as in traditional law communities in Aceh. So maybe that's all I can explain it about. I hope you guys can understand what I'm explained earlier. So thank you for watching until the end. Bye bye.